I'm going to discuss the new DEI orders that were issued by the administration recently, and address some of the takeaways from those orders. I think some of that's going to leak in a little bit to, I think, some of Mike Neary's discussion after my presentation, but hopefully not too much, Mike. Earlier this year in March, the Department of Justice and the EEOC issued joint orders, executive orders. One was a kind of a wide-angle lens look entitled "What to Do If You Experience Discrimination Related to DEI at Work." The second was in the nature of a FAQ, what you should know about DEI-related discrimination at work. And so both of those were sort of part and parcel of some of the messaging coming out from the administration about its views on DEI, and how employers can grapple with that in the workplace. Interestingly, the orders really don't define or DEI in any real meaningful way. Instead, what they try to do is capture what DEI can look like in the workplace, and then provide some basic principles to envelop that and to work around that, as well as some takeaways. So let me try to examine both the overarching executive order that came out first, as well as the FAQs, and then provide some takeaways, both as they apply to those particular executive orders, and more broadly as the DEI discussion relates to other sort of discrimination and retaliation issues, at least from my perspective. So the essence of the orders include the following. One, that employer actions in terms of limiting membership in groups, workplace groups such as resource groups, limiting opportunities, mentoring opportunities, training opportunities, workplace opportunities. If you're doing so based upon a protected characteristic, that's going to be suspect, and that's going to run afoul of these executive orders. Similarly, efforts to kind of balance the workplace by relying upon race or sex or some other protected category, at least according to these executive orders, is going to fall within what these executive orders were trying to address. The executive orders also really bluntly address the concept of there being no such thing as reverse discrimination. The administration's taken the position that discrimination is discrimination, regardless of to whom it, who experiences it, and for what reason. And there's not one set of standard for one category of individuals who are protected under the EEO laws, and another standard for others. There had been some discussion in the courts and some of the opinions as whether or not proving reverse discrimination required a higher standard. And what these executive orders try to do is dispel that notion and say, no, we're talking about discrimination here. Importantly, at the same time as these orders are trying to describe what DEI might look like, they're also fortifying the basic principles of discrimination and retaliation. So the executive orders have a nod to the recent Supreme Court decision, which came out within the past year or so, which talked about what someone needs to show to establish discrimination. And it's really what the Supreme Court referred to as some harm. And that concept is baked into the executive orders as well. Interestingly, that's a lower standard and a more relaxed standard that had existed previously. Employers cannot justify or attempt to defend, using race or some protected characteristic in violation of these executive orders, and make the argument that it's a business necessity or it's in the interest of diversity. Those are going to be non-starters in terms of from the administration's perspective. So what to do? What are the takeaways from these executive orders? Taken together, these two executive orders really do several things. One, they place a premium on making employment decisions based upon merit. Secondly, they place a premium on providing opportunities regardless of protected category. If employers have affinity groups, if they have resource groups, they have to be open to all. Training opportunities, again, need to be open to all and not limited based upon a protected category. One of the takeaways is also that it places a premium on having hiring decisions and, quite frankly, all personnel decisions centralized. It's probably more dangerous now than ever to have these hiring decisions sort of decentralized, where one manager gets to do one thing and another manager is doing something at odds with that decision. So centralizing decision making is going to be critical. Training managers on factors which are both lawful and unlawful, which they may consider in terms of hiring, termination, promotion, and transfer decisions. Ensuring that decisions that are made regarding hiring, firing, termination, promotion, transfers, et cetera, are based upon merit. Is there an objective way to defend those decisions and justify those decisions that is empirical and that is rational? The other part of these executive orders that I think is really important to keep in mind is what it doesn't do. You still have state and local laws that have anti-discrimination, prohibitions contained in them. And there's a bit of a misperception out there, at least in my experience, that because of some of the energy from the Trump administration and the DEI concerns that are being articulated in these executive orders, that somehow the standards for discrimination are going to be relaxed at the state and local level. And I think that's a really dangerous proposition for employers. So what do I mean by that? You've got the federal overlay of the federal EEO laws, as all of us know. You've got the state and local laws that also prohibit discrimination. So these DEI orders really are impactful to the extent they're going to be impactful and adopted by the courts, which remains to be seen, primarily at the federal level, in terms of the federal enforcement of these anti-discrimination laws. But we still have the web of state and local laws that are going to be enforced. And those may get enforced independently of what's happening at the federal level. So let me just sort of say that again. The DEI orders, for however they may be perceived by employers in terms of maybe relaxing some of the requirements for decisions that are made in the workplace, they are still going to be subject to it and analyzed through the lens of state and local laws as well. So again, all the best practices that we've tried to have in place for years about defending and preventing these types of claims continue to exist, and even more so. You're going to want to take a look at your existing policies, particularly if you have a DEI policy, to see if that needs to be refined, revised to address these executive orders, and that should be done with the assistance of counsel. You're going to want to check and double check, actually, to find out if you have employment practices liability insurance for claims that could arise after these executive orders have been issued. Again, you're going to want to look from the EPLI perspective at the nature and the scope and the extent of the insurance coverages which you have. Are they sufficient to cover substantively the different types of claims which could exist now? And are they in sufficient amounts to provide the protection that you need? One of the questions that's left a little bit unopened by these executive orders, and I think remains to be seen, is whether employers are going to be able to use, socioeconomic factors as part of their decision-making process when it comes to certain hiring decisions. And I think that issue, I think the jury's still out on that, and it remains to be seen as to whether that's going to run afoul of these executive orders. Having said all this, there are still some companies out there that are clinging very strongly to their existing DEI policies and believe that that's the proper and correct thing to do for a lot of different reasons, for business reasons, for reputational reasons, and for branding purposes. But those companies that do so need to be mindful of these executive orders and need to be making those decisions really in a thoughtful and measured way with the assistance of counsel to see if there's a way to accomplish the goals which the companies and employers have in terms of promoting inclusion, for example, and do it in a way that's going to pass muster under these executive orders. What the administration seems to be signaling is that these orders are going to be enforced certainly at the federal level and with an eye towards some of the bigger companies, the larger companies. And there's been some indication that that's going to occur relatively soon with some enforcement actions taken with some of the bigger companies, and we've already seen that to some degree. Whether that finds its way down to mid-sized companies and smaller companies kind of remains to be seen, and to what degree. But it's an issue that's out there. So I think in a nutshell, it's really important to do several things. One, review the policies that you have to determine whether or not they are still applicable and valid and appropriate given this new landscape that we're in. Second, a huge premium on training managers, as I mentioned before, but not just on a one-off basis, to do so consistently. Third, ensure that the hiring and all the employment decisions in the workplace are being done on a merit basis, and one that's going to be readily defendable. Ensure that those of you that are working with vendors, consultants, third parties that may be helping you, assisting you in hiring, that you're examining their policies and procedures in terms of hiring, because if they happen to be deemed to be your agent for purposes of the hiring, and they may very well be, then the employers may very well get tagged with the acts and omissions of third parties that we're using in the hiring process. Mike Neary and I wrote an article on these executive orders, which I think is on the website, which we will make available at the end of the presentation. And we'll allow time for Mike. I think that's what I have for now. If there are any questions, I'm happy to address them.
Thank you, Mark. It looks like we do not have any questions at this time. For those of you who are asking, some of our presenters will have slides, others will not, and we will distribute the slides that are presented today after the webinar. So turning it over to you, Mike.